It is completely ridiculous to have a situation in which two different levels of government compete for who will pursue justice.
Because for the first time, we are not waiting on the federal Justice Department, which told the city of New York that we could not proceed.
I heard this last night in the Democratic Party presidential primary debates last night in Detroit. They were saying on stage that the reason why the state government and local government couldn't be responsible was because this federal government department, this part of the Department of Justice, was competing with them for the case and was promising that they were going to deliver justice. That is completely untrue.
And I'm trying to be straightforward with you and everyone in New York. We're following the law. We've got to give people due process. There will be a result next month.
If police officers, state officials, whomever you are, whatever you do, aren't losing jobs when crimes are committed, whether on purpose or by accident, regular people don't understand.
The whole thing doesn't make sense. If we could do it all over again, and we're talking about this happened over 2 presidential administrations, 5 years, it's just unfathomable. It's never happened before. And that doesn't take away the pain of the Garner family or the sense of injustice that everyone is feeling. The whole thing is messed up from day one, right? It should never have happened from the beginning. Justice Department should have done its job. We now know we can't depend on them. We're going to do things differently going forward.
The death of Eric Garner and the inability of the American political system to cope with it in the years that followed thereafter is a really important case study for all of us to learn from, not just Americans, for people all around the world in all kinds of different justice systems. And by the way, note, I did not just say the failure of the police to cope with it. I did not say the failure of the court system. I mean the failure of the whole political system, of the whole democratic society of the United States. I would say that the fundamental problems at work here were already evident back in 1992 with the Los Angeles riots. I am not thinking primarily of the police role in the Los Angeles riots. I'm actually thinking of the death of Letitia Harlins. So for those of you who don't remember, many of you watching this video were not alive, and many of my viewers are not from the United States of America. One of the most important elements of the 1992 riots in Los Angeles was violence of African Americans against Korean immigrants, specifically Korean Americans who owned corner stores, small shops, grocery stores, that sort of thing. Why was that? At the same time as there were other incidents of police brutality and hostility of the African American public against police officers, at the same time there was also the brutal and unprovoked slaying of a teenage African American girl in a corner store by a Korean American shop owner. Now, the difference between the I Can't Breathe controversy, the Eric Garner controversy that I'm talking about in this video, and the trial of Letitia Harlins, is that the trial of Letitia Harlins did successfully convict the slayer of a manslaughter sentence. They were charged and convicted with manslaughter. However, after this person was found guilty, she was sentenced to merely a $500 fine and 400 hours of community service. If the judge had served the sentence by the books and the sentence as recommended by the jury, then the killer would have received 16 years in prison. And instead, she did no prison time. She didn't spend one day in prison. She paid $500 and did 400 hours of community service for murder. Now look, to reveal my own bias in this, in the death of Eric Garner, I believe the correct charge would be murder of some kind. In different jurisdictions, there's a question of would this be first-degree murder, second-degree murder, or third-degree murder. Different societies are going to have to present an array of options for how murder is accounted for. In the United States of America, a lot of people don't know this, the definition for premeditation is very precise and very exacting. So the death of Letitia Harlins in Los Angeles back in the 1990s, that was premeditated murder, even though it was spontaneous. Spontaneity and premeditation are completely different things. Now, it's true, the shop owner, the woman sitting behind the counter of the shop, she didn't wake up that morning and plan in advance to kill this young woman, but that's not what premeditation means legally. Just the span of time where the shop owner got angry at this young woman and then went to get the gun was under the counter, and took the gun out and decided to kill this young woman, that makes it premeditated murder. That's all it takes to qualify as premeditation. So the United States, for something to be not premeditated, it has to be a situation like you're walking down the street and someone jumps on your back from behind, and you turn around and shoot them. Maybe you don't even know who they are. It has to be that spontaneous, where there's no capacity for judgment. There's no option to take another course, or there's very little. Of course, there's always a choice to take another course, but it's very, very narrow what would count as not premeditated. And the most charitable thing I could say for the judge in that L.A. County example from the 1990s, Korean shop owner shooting and killing a teenage black girl, the most generous thing I can say is I think there is a tremendous reluctance in the American legal system to really impose murder on any situation that is not a Hollywood movie version of what murder is supposed to be. Many, many, many Hollywood movies depict the American legal system, and they influence the whole world. Our sense of justice and the process of the law globally, even in China, even in Europe, our sense of what the process of the law is supposed to be is shaped by American TV shows and American movies that partly glamorize the American legal system, partly misrepresent it, and partly criticize it. Partly they offer a critique of the shortcomings of that system. But nevertheless, the idea of what murder is supposed to be, I think even for judges and people in this culture, it doesn't match what this clerk did in the story. So I think she was the wife of the owner of the store. She was more or less the owner and manager of this corner store. This woman spontaneously deciding to shoot someone because she got angry and she was accusing this young girl of trying to shoplift. I mean, even if she were guilty, she shouldn't be shot for shoplifting. But nevertheless, in fact, the police had videotape footage here. So again, you see the comparison to Eric Garner. There was videotape footage proving exactly what happened. There were also 2 eyewitnesses. I have read the direct eyewitness statements from one of those 2 people. They were very young at the time. I forget if they were children or teenagers. She was quite a young girl who was in the shop playing a video game, playing an arcade game. And she saw and heard everything that happened. So I saw a long written statement from her, written years later when she'd grown up, but she, remembered it all and reflected on it. She remembered what she said in court. So it was really a very open and shut case. Eyewitness statements about exactly who said what and who did what, and you can match that up with exactly what happened in the videotape. There was no possibility that this girl was shoplifting. No reasonable, rational person could have accused her of shoplifting. But of course, even if she was attempting to shoplift, to shoot her dead in this circumstance, I mean, it wasn't a situation where, for example, somebody at the counter was defending themselves when a thief is trying to grab money out of the counter, out of the till. There are some scenarios of that legally are very different. Whether or not they should be morally or ethically different is another story. So, look, we have a situation where cultural expectations do not match up with the framework provided with the legal system. There is a tremendous cultural reluctance, which of course you hear from conservatives and everyone else. There is a cultural reluctance to charge a police officer with murder, whether it's first-degree murder, second-degree murder, or third-degree murder, to charge them with murder for the circumstances that are shown in such brutally obvious detail in the filmed death, the slaying of Eric Garner. Now again, I will reveal my bias in this case. I have a formal education in political science. I studied political philosophy all my life. It's really easy for me to say with complete detachment that what happened in that videotape, the death of Eric Garner, is murder. Period. It's very easy for me to look at that and say this should be tried as murder for a police officer the same way it should be tried for a normal citizen. But the real tangled knot we get into here, which has been made even worse by various levels of political dishonesty, as different political parties try to package this into a kind of product for popular consumption,
They are waiting for justice, and they're going to get justice. There's finally going to be justice. I have confidence in that. In the next 30 days in New York. You know why? Because for the first time, we are not waiting on the federal Justice Department, which told the city of New York that we could not proceed because the Justice Department was pursuing their prosecution.
Really, there's a very active campaign ongoing right now in 2019, especially within the Democrat Party, within the debates for who's going to be the next president of the United States. There's a real attempt to misrepresent the significance of what happened legally. And that was probably true to some extent 5 years ago. I think it's worse now, the levels of dishonesty. And of course, one of the most fundamental reasons for that dishonesty is the discomfort of members of the political elite with the reality of just how awful and dysfunctional the American justice system is, and the total reluctance to actually reform that justice system. Okay, so what I'm about to say first is not offensive to anyone. It's not offensive to everyone. That's why I should say that. This is not offensive to everyone. It is completely ridiculous to have a situation in which two different levels of government compete for who will pursue justice. And that is part of the story of what happened here. You had a federal department, you had a subsection of the DOJ, the Federal Department of Justice, publicly competing for the opportunity to press charges on this case. Now, if you have an education in political science, it is completely obvious from day one that under the writ of the law, the DOJ case, the federal department case, would fail. That it would have to at some point stop, be canceled, or be thrown out of court. Even if you passed a new law, you can't make that law retroactive. It's too late. It could affect future cases. Okay, the remit of this special section of the Department of Justice is only to handle civil rights cases. Follow this carefully. Civil rights cases in which the offender, in which the transgressor, put it that way, the person transgressing the law does so willfully. Now that is a very poorly written law. It's unclear to the general public. It's probably unclear to some lawyers what that means. Why willfully? Why would you use an adjective like willfully or willingly? What does that mean? The purpose of that adjective is to constrain the scope of applicability. Okay. Typical situation. A person has a conflict with their landlord. The landlord is somehow cheating them or ripping them off. And then they talk to other tenants in the building. And they also say, some of them say, hey, they also have had this problem with the landlord. If your landlord is doing this to you, that is a violation of your civil rights. So can you go to this federal Department of Justice and say, hey, you have a special section dealing with civil rights violations. Help me out. Help us out. We have a landlord violating our civil rights. No. The implied meaning, the significance of these words, willingly, willfully. The DOJ Civil Rights Department will only handle your case if it's a situation where the landlord was engaging in effect, racial discrimination or something closely similar to racial discrimination, willfully, willingly doing so. What does that mean? It has to be a scenario in which you have a landlord, let's say it's a landlord who refuses to allow mixed-race couples to move in to his properties. Let's say it's a landlord who tries to segregate, to have all the black people over here, all the white people over here. So what the law is meaning to imply is that cases are only elevated from the state level to this federal level special department if and only if you're talking about systematic and intentional racism or some other kind of bias that's equivalent to racism violating people's civil rights. So as you know, by allegory, we now have this kind of civil rights discourse being applied to discrimination against homosexuals or discrimination of any kind that's comparable to racism. Now, if the law were written to say that, clearly, if the delimitation of the role of responsibility of the federal government were clear in this way, you wouldn't have the ridiculous situation we have now. We are having lies, I can only call them lies, stated by major politicians that the reason why the state government investigation and trial of the police officer, or police officers plural, responsible for the death of Eric Garner. The reason why those legal proceedings failed, they are saying, I heard this last night in the Democratic Party presidential primary debates last night in Detroit. They were saying on stage that the reason why the state government and local government couldn't be responsible was because this federal government department, this part of the Department of Justice, was competing with them for the case and was promising that they were going to deliver justice. That is completely untrue. If you just even look up Wikipedia for the timeline of this case, the state-level prosecution already failed years ago. Now, why did it fail? Basically because the whole system is bad. Because what you need is a law that states very plainly, maybe with some delimitations, a police officer is responsible for his or her own moral conduct to the same extent as a civilian. If a police officer does what you see in the video, I think they should be tried with a civilian on a completely equal basis. I do not think you should have two classes of human being with two different sets of law applying them. Now, in the United States, a soldier in combat is not tried under the same law as a civilian in peacetime. And of course, you could have some distinctions. I mean, if a police officer breaks into someone's house, but they do so because they actually believe they have to help someone inside, of course, you have to have laws that are distinguishing what police can do, things that are special or extraordinary. But I mean, from my perspective, in terms of we're asking in a perfect world what would happen here, this absolutely should be a trial for murder. How you want to break down the categories of first degree, second degree, third degree, that's another story. Okay, what are the conclusions we can draw from this? The United States of America never dealt with these problems back in 1992 when the LA riots drew such profound dramatic attention to them. All of these issues, even that one case of a Korean shop owner shooting dead a black teenager, and then the reaction that happened after that, and the discretionary power of the judge to give this woman a zero days in prison for murder. You can call it manslaughter. It's just murder of another kind. And it was premeditated. By legal definition, it's premeditated murder. Call it manslaughter if you want to. And this woman didn't spend one day in jail. And boy, $500 for murder. It's sickening. I don't think any amount of money can make up for murder. But why was it $500 and not $5 million? It's sickening. Okay, anyone who was alive at that time could have stopped, woken up, and said, wow, we have really profound problems here with the American justice system. Okay? Of course, there are many other cases, especially cases involving police misconduct. But the knot of questions that came together and was pulled tight in Los Angeles in 1992, anyone who remembers that, anyone can live through that, could say, hey, all these questions have been asked before, including specifically police brutality against African Americans and what happens in the court system and how everything police do is considered to be in good faith and swept. These problems were all spelled out. Guess who was alive back in 1992 and lived through that? Barack Obama. If any of us are being honest with ourselves, the question we have to ask is, why did Barack Obama do nothing about this for 8 years? Whether you look at the fundamental problem as being federal government departments competing with state government departments, it's a problem in many ways. The problem was created because back in the year 1830, the United States was playing a dishonest game of pretending America was composed of states, when in reality it was composed of both states and territories. There's a reason why the laws are so vague and contradictory and self-defeating about who is responsible for what, and that is because a large part of the history of the continental United States had to do with the interaction between states and territories. To a limited extent, it still does. Shout out to American Samoa, shout out to all the U.S. Army bases and other unincorporated territories that are still part of the American Empire in reality. But that was a much bigger deal between 1750 and 1850 in terms of shaping the way the federal government and local government relate to each other. The creation of the FBI is much later than all that, but it only makes things more complicated. Blah, blah, blah. Long story. It's a long story of nobody wanting to take responsibility and actually set up a systematic, well-working justice system for something as obvious as murder. Murder is, pretty central to our concept of how the justice system is supposed to work. Secondly, there are even deeper roots here, which is that throughout the whole of the British Empire, there was a profound cultural and legal standard that no soldier and no police officer could ever be held responsible for actions undertaken in good faith. You find that in the British Empire, not just in Canada, Australia, the United States. You find that even in India. Also, by the way, when you go back to the old days, there really was no distinction between a police officer and a soldier. When you go back 200 years or something, somebody with a gun who represents the government in some sense. In Canada, it could even be someone with a gun working for the Hudson Bay Company. We had corporate armies, we had corporations with crown powers given to them by the Queen, and then they had their own police. All kinds of, and of course, colonization companies in India and all these things. So it was a very different situation, and having a really firm distinction between the military and the police, or officers of the peace, somewhat later development. But there was a profound conviction that no police officer should be held responsible for anything they do as long as it was done in good faith. So thus, police recklessness. Police were immune from charges for anything that was due to recklessness or sincere incompetence, where they were trying to carry out their duties, they just ended up massacring people, or they ended up choking one person to death. If you go back to the period immediately before the American Revolution, it's a great irony that the hatred of Americans against the British Empire was very largely fulminated by, it was based on, it was a reaction to the brutality of British soldiers, and sometimes British police officers who were kind of the same as soldiers, in precisely these circumstances. That many Americans stood up and said, hey, we don't want to be treated this way. And yet they created actually a legal system and a political system that very much continues the same brutal, imperious powers of the police and military that the British Army was notorious for in those same 13 colonies at that time. The British in India set up these terrible practices of where no officer could be held accountable for anything they did in good faith. And what that meant, in effect, was the only type of crime a police officer could be held accountable for would be something like corruption, taking bribes, not acting in good faith, or some kind of systematic and intentional exploitation of the people. Just as, and here's the parallel, you have this vaguely written law that this police officer could only be held accountable if he willfully violates someone's civil rights. So this police officer, in order for the case to be elevated to that Department of Justice federal charges, the reality, this is plain as day from day one, it was obvious 5 years ago, it was obvious any time if you just read the law and how Department of Justice federal jurisdiction applied to this, okay, the only way that this police officer could have been held accountable by the federal government, by the DOJ, would be if he were systematically and intentionally violating this person's civil rights. And that is irrelevant to the charge we're discussing here, which is the reckless and irresponsible use of authority, the reckless use of violence, and also, not to put too fine a point on it, murder.
The biggest gang in this city, you know that, de Blasio, you know what we say? The biggest gang in the city is the police.